Whatever your focus is, this is the opportunity to build that future. This is the legacy I want to leave behind, and to leave the earth one day with the confidence that that's been done. So as we get to the topic of estate planning, can quickly become overwhelming, daunting, something we don't really want to talk about, the final days and what happens after we're not here. It can be complicated, and it's often somewhere where clients get held up. They know maybe it's something they need to do, but not quite yet. I just want to hit on 2 points around this. It could be one of the most beautiful things that you're able to do. And what I mean by that is it's the opportunity, one of the last opportunities to set up a legacy that is impactful, and in many different ways that can be brought out. So one, it could be charitable intent or for the community around you, setting up a fund or something perpetual that may be able to support a cause you care about or the people you care about. Could set up your family for generations of success, have the opportunity that maybe you didn't have and that you'd like to lead in and give a chance to fund college or do different things that matter. Whatever your focus is, this is the opportunity to build that future. And what we refer to a lot is control from the grave, to say, this is the legacy I want to leave behind, and to leave the earth one day with the confidence that that's been done. I built that as it needed to be. The other important thing is that if you don't do this work on the estate planning, things can go wrong. And I'll start with one more fun story. Is if you're familiar with the formerly Redskins football team, now the Commanders, they used to be owned by someone who I revered, Jack Kent Cooke, who was a wonderful man, wonderful owner. And they just built the new stadium. And right before that, Jack Kent Cooke passed away. His family inherited the Redskins from him. And unfortunately, he had not either done or updated his estate planning to the point where when his family inherited the Redskins, it generated a tax bill that they owed that they did not have the money to pay. So they had to make a decision. We got to sell some things. I don't know the extent of their estate, but I imagine the Redskins were a pretty significant part of that estate. So they had to sell the Redskins. Dan Snyder took over. I don't know how anyone here is a Redskins fan or a football fan or not. I don't think it went particularly well from that point going forward. I wish Jack Kent Cooke could have taken care of his estate planning, is all I need to say about that. Another story, and this is real, and this was a client that we worked with at the firm. It was a mom and dad. They were both, one was a doctor and one was an attorney, and they made very good money, and they had worked really hard to build an estate that was something that was pretty impressive. And they had 2 young children, and unfortunately, the mom was diagnosed with breast cancer in a late stage. And after a battle against that, she passed away a few years into that battle. And tragically, it was shortly after that event, their dad was driving home and was hit by another driver, and he also passed away. So over the course of a very short period of time, their 2 children were left without parents. It was an absolutely awful, awful situation. They had built a will, and the will described how assets were going to be handled and who would be the guardian of their children. The guardian of their children was going to be one of their neighbors from where they lived. They were estranged from their parents. I think one of the sets of parents was no longer alive. The other set, they were not in good terms in relationship, and they were not in a good position. They had never met the kids, never had any relationship with them. So the will described where things were to go. So it goes to the courts through the probate system, and it was going to be moved on. And the parents of the mom who had passed away showed up to court and argued that they should be the guardians of the children after this happened. Granted, they have never met these kids or been involved in their life at all. The court looked at the will, which did not name them, and decided in her favor, as blood was thicker than water, as the saying goes, and allowed those parents to become the guardians. Now, I can't say that I know the motivations here, but I can tell you it definitely feels in some ways like this was an opportunity for them to change their lifestyle, to get access to cash and resources that were a part of this transfer. I hope those kids are doing well, but I can tell you that was not the parents' intent. They did not want them to be raised by their parents. And it's heartbreaking to know this occurred. The reason I tell the story is, if there's one thing that you take away from this estate planning, from this entire course, if you have young children, if you can set up a will that is describing the beneficiaries, who will care for the kids, how things will work, who gets what, but then additionally set up a revocable trust. And that is not something, if you don't know much about trust planning, it often is perceived as, well, I'm not a person who needs a trust. That's for other people in a different category. No, it is for control of assets from the grave. And what that would have done in this situation is there would have been a vehicle that owned the assets, that defined the guardian of the children as the trustee of those assets and the one person who had access to them, only for the children's benefit, for life, health, and other basic needs. If that had been there, I'm not so sure those parents would have shown up to petition the court to be guardians. That's a simple fix that I encourage everyone to do if you have not, as there is no way to send money to a kid under the age of 18, and the only way to protect that from the grave is utilizing a revocable trust. So I'm not an attorney, but I want to make sure that that is something that's looked at with an attorney through this process. So additionally, there is moving past the basic estate planning, which I hope we can all take care of following this conversation. There is the advanced estate planning component. And this becomes an additional complexity that has a lot of really awesome things you can do, really be customized to what you're trying to accomplish, with the main point being providing opportunity to really do some powerful things for charitable intent and philanthropy, then also primarily only making sure your estate pays the taxes required and nothing else, and protecting the rest of those assets for your family and for generations to come. So tax efficiency on the advanced estate planning. And with that said, without going through all the different ways and processes that can possibly happen, I want to hit an example to kind of show you this process and how cool and powerful it can be to achieve those goals. And then we'll talk a little bit more after that. All right, so as we pull this example, this is going to be a lot of moving parts, but I wanted to show this because I think it really illustrates the power of understanding what your goals are in your estate, what you want to see happen, and then utilizing all the tools that exist, which goes, again, all the way back to the beginning. What's the plan? What are the tax efficiencies? All the way through every piece of your business to say, let's get a plan that makes this work exactly how we want it to. So, and this is an example from a client we worked with. So wanted to give some earlier information that in this case, we had originally gone in with the client and noticed that they were taking, before we had worked with them, about $650,000 a year of W-2 income. We had asked them the question why, and they had said, we don't really know. That's just what our CPA told us. So at the time we looked at this, the Social Security wage base was $130,000. Anything they were taking in W-2 above that was just additional tax burden for no particular reason. We looked at this and the CPA agreed with us that they should adjust this to be $130,000 of W-2 each through the income, and then $520,000 a year of distribution, which yielded approximately $130,000 a year in tax savings through this process. So going into this plan, significant change from the same income coming out on taxes that are available to them. So when we go into the program, there are essentially 4 individuals that needed to be addressed here. There was the father and the mother, who were both co-equal owners through marriage of this business. The father was primarily running it. Then there was a son and a daughter. And the father's goal was to make sure he transitioned the business to his son, who was working in the business, so that he could run it when the father retired. But he wanted to make sure the daughter received an equal value for the business. He didn't want everything to go to the son, as that was primary value in his estate. So he wanted to develop a plan to equalize this and make sure it was taken care of effectively. So what we did, working with attorneys of the family, as well as their CPAs, we developed this program, which started with an intentionally defective grantor trust, which is referred to in the industry, so to speak, as an IDGIT. It's also much more fun to say. It took a note received, or a loan payable, that was 90% of the non-voting shares in the company. So the company's stock itself was transitioned into a recapitalization, which means the stock shares had different purposes. So 90% of them became non-voting shares and 10% were voting shares. So the 10% had all the power, all the votes, could make any change it wanted to. but the 90% held value. He sells the 90% stock to the IDGIT at a 40% discount. Now, why could he do it at a discount? Well, those shares weren't voting, so they didn't have the same power and value as the voting shares. The IDGIT, which is a trust set up to own these shares, pays an 11-year note back to the father to cover the cost of what it was received, what it bought at that time. It's very important it wasn't given, it was purchased by the IDGIT through an agreement. That helps to avoid some of the tax situations and other basis position problems that occur from the tax basis. This 11-year note was specifically designed, I know that's an odd year, it was designed for them and the plan we had and the way the numbers worked out in this process. So we also had the IDGIT purchase an insurance policy on the father, which covered the full cost of that note, so that if he were to pass away, this entire program could be completed at death, and the mother would have everything she needed, as you'll see as we move forward in this process. So now the son was the beneficiary, sole beneficiary of this IDGIT. And therefore, any of the proceeds that came through the IDGIT of the shares that it purchased would be payable to the son. So the business stock distributes the money, and that money is distributed primarily for the note payment. So the son then takes the money and pays it right back in to the IDGIT to cover the cost of the note to the father. That note payment would go back to the father and mother. They would use that for their income sources, but then also have significant additional savings they were putting into investments and other strategies to develop a core fund for them to use later as we go through this process. Once the son finishes the entire payment through the IDGIT and now owns the 90% non-voting shares, he receives all the stock and the IDGIT is dissolved. And this would be completed whether or not he completes an 11-year note or if the father were to pass away. Once this is done, the father and mother own 100% of the business value plus interest on the note. Well, they still do own a 10% share, but a minority share of the company. And that at that point could either be gifted to the son through gifting rules, lifetime exemptions, or potentially the son could buy the remaining 10% at that time, which is a minority share. Now, the father and mother, again, have the business value in their estate, which was adequate based on that plus their other assets to cover income without question the rest of their life, without decreasing that business value. In fact, it was designed to increase until they were to pass. When the father and mother passed, their estate declared that 50% of their remaining estate at that time would go to the daughter and the son. Equalization of this is that the father received the entire value of the business to his name, the son purchased the business, and now had the risk and hopefully reward of running a business going forward, but he wasn't given anything. And the father and mother were then able to equalize what they gave to the son and daughter exactly the same as if the son had never been involved with the process. So in conclusion, I know there's a lot of moving parts here. I'm not expecting anyone to see this and be an absolute expert on how this whole program works. It's just here to be an example to show when you have a plan like the father and mother did, and they know what they want to have accomplished, there's a lot of really cool and effective ways to get to these types of solutions that are going to be protected through the structures that we're able to use using advanced estate planning techniques. So I hope you understand, showing that example wasn't to therefore say this would be something you use in your plan. Every time we go through estate planning, there's going to be very different outcomes and different tools and processes used. And it can be complicated. It can be a little overwhelming. It can be a little unnerving to say, I'm not really sure that I fully get this, but I know we got to get to a solution. And working with someone who's able to really bring that to a simple level or to the level that you need to understand is critically important. And that is usually a team, not just an attorney, but the advisors and trusted folks you need around you that are guiding you, understanding your vision, trying to get you to that point, and really having that trusted team hold your hand through this whole process and make sure that you get it done and hold you accountable. So knowing the complications and reservations some people have with making these final decisions and moving assets and setting up these unique trusts, I want to close out the series with Mike White kind of giving his thoughts on his experiences on working with clients through estate planning and what it really boils down to at the end.
Over my career, and this isn't going to stop after my career, the tax laws around estate planning continue to change, and they'll be changing again soon, okay? But here's what doesn't change with estate planning. And I think about, I have a very good client in town. I can tell you it's a very, very substantial client in town. I mean, hundreds of millions of estate value versus, tens. And I remember the conversation went like this. I have people to handle that stuff. But as I asked the questions I needed to ask, it became apparent the estate planning wasn't addressed at the level it needed to be. And it's funny how different people grasp difficult concepts differently. But the one that just resonated with him was I just drew this picture of these poker chips on a piece of paper, just saying that this is $200 million worth of chips, a lot of real estate in there. I bet you those chips on the bottom were put there when you were in your 20s. He goes, yep, actually they were. I can tell you where the property is. So you have $200 million of chips, and you've made the conscious decision to give at least half of those to the IRS once you and your wife pass away. And I don't understand why. You spend your whole lifetime building them. He goes, well, I haven't made that decision. Well, your plan has made the decision to give at least half to the IRS. And God forbid it's during the 2008 real estate financial crisis that impacts the value of the chips. You could lose 2/3 of those chips. It's why the Washington Redskins were lost, okay? Because the estate planning didn't end well, and so we had a new buyer years ago, okay? So, and other sports teams have been lost to new buyers because of poor estate planning. Here's my point. Do you know if you just took 2 or 3 chips off the bottom of this stack, put them over here in a trust, the estate taxes will be taken care of and the remaining chips go to your family. That's estate planning. And the rest is history. Because we dug into that, got with his other advisors, and we did his estate planning. But the concept was, let's protect the chips for my family and set up a way to do that so I don't lose them.
If you're looking for more educational content to expand on this a little further, we have a Business U workshop, which is a longer format workshop here over a 2-day period that allows you the opportunity to sit down with other business owners in the room, to ask specific questions to your needs, and to dig into these topics all the way through the nuts and bolts for everything that may be of concern to you or that you need to know specifically. If you'd like to attend a workshop, there's some information below. Finally, we've been working with business owners in this capacity for almost the last 40 years. And if you're looking for that advocate, that partner to be with you as you're guiding your business, we'd love to have you be a part of the team. And we'd love to see you be that person who brings their business to the ultimate value as their most valuable asset. Thank you.